The Hindu Adoptions and Maintenance Act, 1956. Act No. 78 of 1956, December 21, 1956. Be it enacted by Parliament in the 7th year of the Republic of India as follows. Chapter I. Preliminary. 1. Short title and extent. 1. This Act may be called the Hindu Adoptions and Maintenance Act, 1956. 2. It extends to the whole of India except the state of Jammu and Kashmir. 2. Application of Act. 1. This Act applies a. To any person, who is a Hindu by religion in any of its forms or developments, including a Virashaiva, a Lingaya, or a follower of the Brahmo, Prarthana or Arya Samaj. b. To any person who is a Buddhist, Jaina, or Sikh by religion, and c. To any other person who is not a Muslim, Christian, Parsi, or Jew by religion unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein if this act had not been passed. Explanation: the following persons are Hindus, Buddhists, Jainas, or Sikhs by religion, as the case may be. a. Any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jainas, or Sikhs by religion. b. Any child, legitimate for illegitimate, one of whose parents is a Hindu, Buddhist, Jaina, or Sikh by religion and who is brought up as a member of the tribe, community, group or family to which such parent belongs or belonged. b. Any child, legitimate or illegitimate, who has been abandoned both by his father and mother or whose parentage is not known and who is either case is brought up as a Hindu, Buddhist, Jaina, or Sikh, and c. Any person who is a convert or reconvert to the Hindu, Buddhist, Jaina, or Sikh religion. 2. Notwithstanding anything contained in subsection 1. Direct contain cans of the Union Territory of Pondicherry. 3. Person who, though not a Hindu by religion, is nevertheless a person to whom this act applies by virtue of the provisions contained in this section. 3 definitions in this act unless the context otherwise requires. a. The expressions custom and usage signify any rule which, having been continuously and uniformly observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group, or family. Provided that the rule is certain and not unreasonable or opposed to public policy, and provided further that, in the case of a rule applicable only to a family, it has not been discontinued by the family. b. Maintenance includes I. In all cases, provision for food, clothing, residence, education, and medical attendance and treatment. 2. In the case of an unmarried daughter also the reasonable expenses of an incident to her marriage. c. Minor means a person who has not completed his or her age of 18 years. 4. Overriding effect of acts save as otherwise expressly provided in this act. a. Any text, rule, or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which provision is made in this act. b. Any other law in force immediately before the commencement of this act shall cease to apply to Hindus in so far as it is inconsistent with any of the provisions contained in this act. Chapter 2. Adoption. 5 adoptions to be regulated by this chapter. 1. No adoption shall be made after the commencement of this act by or to a Hindu except in accordance with the provisions contained in this chapter, and any adoption made in contravention of the said provisions shall be void. 2. An adoption which is void shall neither create any rights in the adoptive family in favor of any person which he or she could not have acquired except by reason of the adoption, nor destroy the rights of any person in the family of his or her birth. 6 Requisites of a valid adoption. No adoption shall be valid unless I. The person adopting has the capacity, and also the right, to take in adoption. 2. The person giving in adoption has the capacity to do so. 3. The person adopted is capable of being taken in adoption, and 4. The adoption is made in compliance with the other conditions mentioned in this chapter. 7. Capacity of a male Hindu to take in adoption. Any male Hindu who is of sound mind and is not a minor has the capacity to take a son or a daughter in adoption. Provided that, if he has a wife living, he shall not adopt except with the consent of his wife unless the wife has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. Explanation: if a person has more than one wife living at the time of adoption, the consent of all the wives is necessary for any of the reasons specified in the preceding proviso. 8. Capacity of a female Hindu to take in adoption. Any female Hindu a. Who is of sound mind, b. Who is not a minor, and c. Who is not married, or if married, whose marriage has been dissolved or whose husband is dead or has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind, has the capacity to take a son or daughter in adoption. 9. Persons capable of giving in adoption. 1. No person except the father or mother or the guardian of a child shall have the capacity to give the child in adoption. 2. Three. The mother may give the child in adoption if the father is dead or has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. 4. Where both the father and mother are dead or have completely and finally renounced the world or have abandoned the child or have been declared by a court of competent jurisdiction to be of unsound mind, or where the parentage of the child is not known, the guardian of the child may give the child in adoption with the previous permission of the court to any person including the guardian himself. 5. Before granting permission to a guardian under subsection 4, the court shall be satisfied that the being for this purpose given to the wishes of the child having regard to the age and understanding of the child, and that the applicant for permission has not received or agreed to receive, and that no person has made or given or agreed to make or give to the applicant any payment or reward in consideration of the adoption except such as the court may sanction. Explanation for the purposes of this section. I. The expressions father and mother do not include an adoptive father and an adoptive mother. IA. Guardian means a person having the care of the person of a child or of both his person and property, and includes a guardian appointed by will of the child's father or mother, and b. a guardian appointed or declared by a court, and 2. Court means the city or civil court or a district court within the local limits or whose jurisdiction the child to be adopted ordinarily resides. 10 persons who may be adopted. No person shall be capable of being taken in adoption unless the following conditions are fulfilled, namely: I. He or she is a Hindu. 2. He or she has not already been adopted. 3. He or she has not been married, unless there is a custom or usage applicable to the parties which permits persons who are married being taken in adoption. 4. He or she has not completed the age of 15 years, unless there is a custom or usage applicable to the parties which permits persons who have completed the age of 15 years being taken in adoption. 11 Other conditions for a valid adoption. In every adoption, the following conditions must be complied with. I. If any adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son, son's son, or son's son's son, whether by legitimate blood relationship or by adoption, living at the time of the adoptive father or mother by whom the adoption is made must not have a Hindu daughter or son's daughter, whether by legitimate blood relationship or by adoption, living at the time of adoption. 3. If the adoption is by a male and the person to be adopted is a female, the adoptive father is at least 21 years older than the person to be adopted. 4. If the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. V. The same child may not be adopted simultaneously by two or more persons. 6. The child to be adopted must be actually given and taken in adoption by the parents or guardian concerned or under their authority with intent to transfer the child from the family of its birth, or in the case of an abandoned child or a child whose parentage is not known, from the place or family where it has been brought up to the family of its adoption. Provided that the performance of data homin shall not be essential to the validity of an adoption. 12. Effect of adoptions. An adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of the adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to be severed and replaced by those created by the adoption in the adoptive family. Provided that a. The child cannot marry any person whom he or she could not have married if he or she had continued in the family of his or her birth. b. Any property which vested in the adopted child before the adoption shall continue to vest in such person subject to the obligations, if any, attaching to the ownership of such property, including the obligation to maintain relatives in the family of his or her birth. c. The adopted child shall not divest any person of any estate which vested in him or her before the adoption. 13. Right of adoptive parents to dispose of their properties subject to any agreement to the contrary. An adoption does not deprive the adoptive father or mother of the power to dispose of his or her property by transfer inter vivos or by will. 14. Determination of adoptive mother in certain cases. 1. Where a Hindu who has a wife living adopts a child, she shall be deemed to be the adoptive mother. 2. Where an adoption has been made with the consent of more than one wife, the senior most in marriage among them shall be deemed to be the adoptive mother and the others to be stepmothers. 3. Where a widower or a bachelor adopts a child, any wife whom he subsequently marries shall be deemed to be the stepmother of the adopted child. 4. Where a widow or an unmarried woman adopts a child, any husband whom she marries subsequently shall be deemed to be the stepfather of the adopted child. 15. Valid adoption not to be cancelled. No adoption which had been validly made can be cancelled by the adoptive father or mother or any other person, nor can the adopted child renounce his or her status as such and return to the family of his or her birth. 16. Presumption as to registered documents relating to adoption. Whenever any document registered under any law for the time being in force is produced before any court purporting to record an adoption made and is signed by the person giving and the person taking the child in adoption, the court shall presume that the adoption has been made in compliance with the provisions of this Act unless and until it is disproved. 17. Prohibition of certain payments. 1. No person shall receive or agree to receive any payment or other reward in consideration of the adoption of any person, and no person shall make or give or agree to make or give to any other person any payment or reward the receipt of which is prohibited by this section. 2. If any person contravenes the provisions of subsection 1, he shall be punishable with imprisonment which may extend to 6 months, or with fine, or with both. 3. No prosecution under this section shall be instituted without the previous sanction of the state government or an officer authorized by the state government in this behalf. Chapter 3. Maintenance. 18. Maintenance of wife. 1. Subject to the provisions of this section, a Hindu wife, whether married before or after the commencement of this Act, shall be entitled to be maintained by her husband during her lifetime. 2. A Hindu wife shall be entitled to live separately from her husband without forfeiting her claim to maintenance. A. If he is guilty of desertion, that is to say, of abandoning her without reasonable cause and without her consent or against her wish, or of willfully neglecting her as to cause a reasonable apprehension in her mind that it will be harmful or injurious to live with her husband. C. If he is suffering from a virulent form of leprosy. D. If he has any other wife living. E. if he keeps a concubine in the same house in which his wife is living or habitually resides with a concubine elsewhere. F. If he has ceased to be a Hindu by conversion to another religion. G. If there is any other cause justifying her living separately. 3. A Hindu wife shall not be entitled to separate residence and maintenance from her husband if she is unchaste or ceases to be a Hindu by conversion to another religion. 19. Maintenance of widowed daughter-in-law. 1. A Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law, provided and to the extent that she is unable to maintain herself out of her own earnings or other property or, where she has no property of her own, is unable to obtain maintenance. A. From the estate of her husband or her father or mother, or B. From her son or daughter, if any, or his or her estate. 2. Any obligation under subsection 1 shall not be enforceable if the father-in-law has not the means to do so from any co-parsonary property in his possession out of which the daughter-in-law has not obtained any share, and any such obligation shall cease on the remarriage of the daughter-in-law. 20. Maintenance of children and aged parents. 1. Subject to the provisions of this section, a Hindu is bound, during his or her lifetime, to maintain his or her legitimate or illegitimate children and his or her aged or infirm parents. 2. A legitimate or illegitimate child may claim maintenance from his or her father or mother so long as the child is a minor. 3. The obligation of a person to maintain his or her aged or infirm parent or daughter who is unmarried extends in so far as the parent or the unmarried daughter, as the case may be, is unable to maintain himself or herself out of his or her own earnings or other property. Explanation in this section: parent includes a childless stepmother. 21. Dependents defined for the purposes of this chapter. Dependents mean the following relatives of the deceased: I. His or her father. 2. His or her mother. 3. His widow, so long as she does not remarry. 4. His or her son or the son of his predeceased son or the son of a predeceased son of his predeceased son, so long as he is a minor, provided and to the extent that he is unable to obtain maintenance, in the case of a grandson from his father's or mother's estate, and in the case of a great-grandson, from the estate of his father or mother or father's father or father's mother. V. His or her unmarried daughter for the unmarried daughter of his predeceased son or the unmarried daughter of a predeceased son of his predeceased son, so long as she remains unmarried, provided and to the extent that she is unable to obtain maintenance, in the case of a granddaughter from her father's or mother's estate and in the case of a great-granddaughter from the estate of her father or mother or father's father or father's mother. 6. His widowed daughter, provided and to the extent that she is unable to obtain maintenance. A. From the estate of her husband, or B. From her son or daughter, if any, or his or her estate, or C. From her father-in-law or his father or the estate of either of them. 7. Any widow of his son or of a son of his predeceased son, so long as she does not remarry, provided and to the extent that she is unable to obtain maintenance from her husband's estate, or from her son or daughter, if any, or his or her estate, or in the case of a grandson's widow, also from her father-in-law's estate. 8. His or her minor illegitimate son, so long as he remains a minor. 11. His or her illegitimate daughter, so long as she remains unmarried. 22. Maintenance of dependents. 1. Subject to the provisions of subsection 2. The heirs of a deceased Hindu are bound to maintain the dependents of the deceased out of the estate inherited by them from the deceased. 2. Where a dependent has not obtained, by testamentary or intestate succession, any share in the estate of a Hindu dying after the commencement of this act, the dependent shall be entitled, subject to the provisions of this act, to maintenance from those who take the estate. 3. The liability of each of the persons who take the estate shall be in proportion to the value of the share or part of the estate taken by him or her. 4. Notwithstanding anything contained in subsection 2, or subsection 3, no person who is himself or herself a dependent shall be liable to contribute to the maintenance of others, if he or she has obtained a share or if the liability to contribute were enforced, become less than this Act. 23. Amount of maintenance. 1. It shall be in the discretion of the court to determine whether any, and if so what, maintenance shall be awarded under the provisions of this Act, and in doing so, the court shall have due regard to the consideration set out in subsection 2, or subsection 3, as the case may be, so far as they are applicable. 2. In determining the amount of maintenance, if any, to be awarded to a wife, children, or aged or infirm parents under this Act, regard shall be had to a. The position and status of the parties. b. The reasonable wants of the claimant. c. If the claimant is living separately, whether the claimant is justified in doing so. d. The value of the claimant's property and any income derived from such property, or from the claimant's own earning or from any other source. e. The number of persons entitled to maintenance under this Act. 3. In determining the amount of maintenance, if any, to be awarded to a dependent under this Act, regard shall be had to a. The net value of the estate of the deceased after providing for the payment of his debts. b. The provision, if any, made under a will of the deceased in respect of the dependent. c. The degree of relationship between the two. d. The reasonable wants of the dependent. e. The past relations between the dependent and the deceased. f. The value of the property of the dependent and any income derived from such property, or from his or her earnings or from any other course. g. The number of dependents entitled to maintenance under this Act. 24. Claimant to maintenance should be a Hindu. No person shall be entitled to claim maintenance under this chapter if he or she has ceased to be a Hindu by conversion to another religion. 25. Amount of maintenance may be altered on change of circumstances. The amount of maintenance, whether fixed by a decree of court or by agreement either before or after the commencement of this Act, may be altered subsequently if there is a material change in the circumstances justifying such alteration. 26. Debts to have priority. Subject to the provisions contained in Section 27, debts of every description contracted or payable by the deceased shall have priority over the claims of his dependents for maintenance under this Act. 27. Maintenance. When to be a charge. A dependent's claim for maintenance under this Act shall not be a charge on the estate of the deceased or any portion thereof, unless one has been created by the will of the deceased, by a decree of court, by agreement between the dependent and the owner of the estate or portion, or otherwise. 28. Effect of transfer of property on right or maintenance. Where a dependent has a right to receive maintenance out of an estate and such estate or any part thereof is transferred, the right to receive maintenance may be enforced against the transferee if the transferee has notice of the right or if the transfer is gratuitous, but not against the transferee for consideration and without notice of the right. Chapter 4. Repeals and savings. 29. Repeals. Repealed by Act 58 of 1960. 30. Savings. Nothing contained in this Act shall affect any adoption made before the commencement of this Act, and the validity and effect of any such adoption shall be determined as if this Act had not been passed.